Hello and welcome to Unpacking Contract Law, the UK-based contract law podcast delivering unsolicited opinions on new and old contract law cases. The purpose of these podcasts is to provide you with an insight into our thoughts, ideas and ideologies around all things contract law. It also provides us with an outlet for all our opinions, so you listen at your own peril. Each podcast will feature a new contract law case with a discussion from 3 contract law enthusiasts. And it is thus my great pleasure to introduce you to Maggie Hemsworth, Severine Saintier, and myself, Tim Dodsworth. Welcome to Unpacking Contract Law.
Good morning, good afternoon, or good evening from wherever you are listening to us. We have a big announcement. Over to you, Tim.
Do we? No, of course we have a big announcement today. Some may have noticed that the audio quality of our podcast has significantly improved over the last few episodes, thanks to our new sponsor of this podcast. Yes, believe it or not, we are now sponsored. And that is Newcastle University Law School, who have kindly agreed to sponsor Unpacking Contract Law for the next year. We'll tell you more about Newcastle Law School in a bit, but for now, a big thank you.
Thank you very much.
Yes! This also means that we now have an editor, Luke, who is keeping us on the straight and narrow, I think, as far as humanly possible. Thank you, Luke, for all the work you're doing in the background as well. And Severine, let's begin.
Thank you, Luke, as well. I need to add my thanks. So today we are looking at decisions by the Court of Appeal, TRW Limited versus Panasonic. Panasonic, much longer title, but for the sake of brevity, TRW Limited versus Panasonic. It's a lovely, neat decision. I am already disclosing my colours. It's a contract between Germany and England. So it's a contract for the sale of resistors by Panasonic, the German seller, to TRW, the English buyer. Both parties wanted to have the contract on their own terms and conditions. And so this is an example of what we have lovingly got to know, the battle of form dispute. So quickly on the fact, to put everything in context. In 2011, the English buyer signs what is called, in the relationship, a customer file, which stated that the buyer had received and acknowledged the seller's standard terms, and the actual contract itself, the delivery of the resistors, was a couple of years later, but 2011 is important for the signing of the customer file. So quite a bit more than a couple of years later, in 2015 and 2016 respectively, individual sales contracts were concluded and the resistors were delivered. But then TRW was not quite happy with the quality of those resistors, and TRW claimed that they were defective, so therefore commenced proceedings in the English court, and that's where the whole saga unraveled. The terms and conditions of TRW stated that the English courts had jurisdiction and that the contract was subject to English law, and in good battle of form dispute, Panasonic's terms and conditions, which they insisted were incorporated and were governing the contract, were the German courts and German law. And so the High Court had to decide which one prevailed. And the High Court decided that even though usually the battle of form is doctrine as it is lovingly known, is decided by the last shot doctrine. Here, it was held that the seller's terms were incorporated by the signing of the customer file. There is an appeal, and this is the appeal that we are discussing. The Court of Appeal confirms everything that Justice Kerr in the High Court stated. And so therefore considered indeed that there are possibilities to displace the last shot doctrine And here is an example of where the last shot doctrine is displaced. And here we are, German law prevails, and so the dispute is going to be sorted by German law. I should say that, of course, there are jurisdictional issues, but I propose that we put those aside completely, since this is a contract law matter. Not that it is not important or interesting, but I think we can say this is slightly beyond our pay grade. So, what do we
say something?
I was going to say.
Oh, of course, Maggie. Of course. I didn't think you would, you know. But so I think it's a neat decision. I should say that it is heard before Lord Justice Peter Jackson, who gave the decision for the Court of Appeal. Lord Justice Coulson agreed, and so did Lord Justice Burse. Lord Justice Coulson just added a little bit to say that he didn't think there was any need to appeal, and the only criticism of Justice Kerr is that he agreed to have the case appealed. But that's, So I think it's a really neat little decision. Sorry, little in the sense of it's quite short in it to read, which makes a change, but not little in importance. But yes, so I think it's a neat decision, but maybe Tim and Maggie, you disagree with me.
Oh, good-o, because I do as
well.
Oh,
good.
This is not your classic battle of the forms for starters. It reminds me very much of the discussion around nom clauses, no oral variation clauses, modification clauses, sorry. And I'm not sure this can be right. What we're seeing, I think, and I'm sure you'll give more structure, Severine, but I think what we're seeing here is kind of a degree of acceptance. So one is more serious than the other kind of thing. And that seems to be what they're trying to say here. But no, I in short, if that was your question, do you agree with this judgment? No, I do not. Possibly I could come to the same outcome, but the reasons given are, I don't think, right.
Now, I thought that you would have been in favour of this, Tim, because it's banging on about the power of the signature. And I thought you were a fan of the power of the signature from when we were discussing whether the signature sort of trumped any obligation to draw terms to someone's attention. And I thought you were generally a fan about the power of the signature. And the Court of Appeal here is definitely a fan of the power of the signature. Are they not? And
yes.
The striking thing, to my mind, at any rate, I don't know if it's intentional, given that it's a dispute between English jurisdiction and German jurisdiction, is that paragraph 37, when the judge says this is the only occasion, this signing of the agreement, the document presented by the German side, this is the only occasion, to use warfare analogy, he says, when one side walked across no man's land and fraternized with the enemy.
I know, I think the analogy is so funny.
We're looking back to World War I here, with the Christmas Day playing football, as it were. So the analogy here is the English party had walked across no man's land and signed Panasonic's German terms and conditions. So I thought you'd be in favour of that because, there's the power of the signature and the signature must have some legal status. That seems to be all the sort of thrust behind all of this. But are you, like me, having some worries about the power of the signature in this context then?
Not so much the signature. I agree. I mean, first of all, they seem to have agreed. I think that's clear. They agreed on the first moment in time. But one of the great things about contract law is the fact that you essentially can undo whatever you've done before by agreeing again. Right? Offer, acceptance, consideration, and intention to create legal relations, and off you go. You've got a new agreement. And that is part, and this is
but we're sort of assuming that signing episode, as it were, is itself a little mini contract, and that seems to be the way the Court of Appeal looked at it, and they were sort of waving to one side any claim that there wasn't a consideration for this. Do you see what I mean? They're saying that this is itself a little contract, rather like a tendering contract. By signing this, TRW had the chance of buying resistors from Panasonic at some point in the future. But it's a rather peculiar way of the analogy.
Well,
that
I can agree with. And I think that is pretty standard. I think that's pretty common, right? These typical procurement contracts is that you need to go through all this rigmarole first to become part of the company providers, and that you sign documents within that. The difficulty here is that it seems that it's unamendable forever.
I think we need to be careful here. So, Maggie, you called it a mini contract. I would say, given the analogy, so Tim, you used the term procurement. I think we need to be. So they said it was like using analogy here. It was similar to the process of procurement, but this is not procurement here. And so, Maggie, therefore, I think it's even more than a mini contract. It is, and I think Lord Justice Coulson used the thing. It was an umbrella agreement. So I think what they have done here is 2011 is that they have stated, do we agree to contract with each other? Yes. And then 4 years later, okay, so what we need is, the judgment itself does not, doesn't tell us how many. But I want to go back perhaps later to interpretation of the relation. So, Tim, I would disagree with you that it is unamendable forever, because it's just for the, so on that I would disagree. Where potentially there is a problem is that it then in time stops everything which comes afterwards, and then that the court makes, continues on the analogy of war, that this is one way of effectively telling parties, be careful, even though careful drafting, you always want to make sure that you've got the last term. This is an example where the first shot doctrine, for want of a better word, is going to be created. But for me, it is interesting, and perhaps we can come back to it later, as to this is the court looking at how the parties do. And so, Tim, when you said it is, set in stone forever, and that, it can all be started again, here the court actually quite spends some time looking at whether that came out of the blue. And Lord Justice Coulson made the point that actually it doesn't. They had done business together before, we don't know when, but the manner in which they came up with their relationship should not have surprised TRW. So in a way, this is, common sense. And for that reason, the court paid close attention to whether what and how they've done things should have come as a surprise to TRW. And the court said, no, their relationship was clear. It shouldn't have. So it is the point where actually they could have, amended it if they had wanted and if they had made clear. So that's the tiny point I disagree.
I think you've always made my point there. So I think you've almost made my point there. Isn't that exactly what it means when we say that's unamendable? You're saying this master agreement will override pretty much everything. Well, it will override everything.
No, it's trying to say, isn't it? It's trying to say, that's why I was using the term mini contract. It's not a contract of sale. It's a contract that says, if we in the future agree any binding arrangement as to sale, specific items of resistors that's nailed down in specificity like that, then it will be on these terms, but only on these terms. So it's almost, I think, in terms of analysis, I personally think it would be better to argue this as a sort of standing basis upon which an invitation to treat is being communicated. So it's not even an offer. It is Panasonic saying, if you in the future want to enter into negotiations for us for the buying of our resistors, don't try and offer any other standard terms that conflict with our own. So it's not an offer, it's something less than that. But the significance of it is sort of nailing down the ground rules, if you like, for any future negotiations, any future offer. And if you look at Panasonic's own terms, they're drafted rather oddly. Perhaps it's the translation from German to English, I don't know. But they seem to be of the view that the offer of contract of sale would in the future be made by the would-be purchaser, here TRW, and the acceptance would be that of Panasonic, because they talk about it will only be binding when we accept, we give written confirmation or something, or failing that on delivery. So that seems to be how they would see it. And I think that's aligned with English law, isn't it? So really all we're arguing about is what is the status legally of this negotiation or this pre-communication. Hence there's the power of the signature bit that I think the Court of Appeal alighted upon, and also the point, Severine, that you hinted at about this being a standard basis on which Panasonic was dealing generally with TRW group companies, so not necessarily TRW but other companies in the group. That's not quite, I think, how it was analysed by the Court of Appeal. I suppose they had to respond to TRW's claim that if this was a contract, that is not of sale, but as to the terms of possible future relationship, there was no consideration for it. And that's one of the arguments that was made. And that's why I think the Court of Appeal went down the road to try and shut that off by saying, oh, yes, there is, because it's like tendering. And by accepting these terms of Panasonic, you, TRW, have in the future the opportunity or chance of eventually agreeing a contract to buy specific resistors. Because I suppose of this clearance, this security clearance that you'd have to go through, because resistors, I think, can be used in armaments. So maybe there has to be some screening in Germany, for example, of who's buying their stuff. So I think that's how we've ended up at this sort of argument. I don't know what you think about that.
So I have no problem with finding that first agreement is a contract, full stop. Why? You know, of course we can agree. I'll give you £10 if from now on you incorporate my terms and conditions into every contract that I make with you.
Yeah, okay, but what were they really getting? You know, is it realistic to say the purchaser or the would-be purchaser has the benefit of being able to buy their stuff in the future? Is that wholly realistic?
Yeah, absolutely.
It's not like tendering, is it?
It's you'll be part of our preferred realistic supplier, pool. That is, you know, that's like, you know, you join a club, it's a membership type thing.
Yes, but are they is that realistic to say a seller doesn't want TRW's business and therefore you have to go through these hoops to be permitted to join the club? It's
absolutely.
Crazy,
all larger companies do it.
It's not like tendering at all.
All large companies do it. I think it's a common practice. I have no problem with that whatsoever. Yes. And it's something of value, right? You're on a list, so you'll be considered before others, right? It's like priority boarding kind of thing.
Yeah.
Except, of course, you'd be called for boarding. But the idea is that's a really bad example.
Well, I have some trouble with that. I don't think it's commercially realistic.
Yeah, you're going down the consideration route that I think they shot down in that judgment. I have no problem with having the contract. I don't think that's a problem at all. What I have a problem with is to say that it'll override a new contract that comes along later on. That to me seems impossible. Right? How can we bind ourselves when we then have another contract that comes? That to me, and Séverine, you mentioned, I think you were referring to the quote in Chitty, and that's a slight side note here, is that they actually got the referencing wrong. It's not the 33rd edition they're referring to, it's the 32nd edition. Anyway, if we have a look at that, they're also not giving the full quote. They say, well, with careful draftsmanship, you can get out of this. No, it goes on, and it says, the most that a draftsman can be certain of is achieving a stalemate situation. In other words, Chitty is actually acknowledging you can try with careful drafting to override future terms, but it's actually impossible.
But I think if
because the other party can be just as careful, and then you're back to square one.
But I think to answer.
Yeah,
so
sorry, Séverine. I'm getting worked up.
Yeah, I know. It's great. So I think it's just the way the way Maggie, so the way and the terms, framework agreement, umbrella agreement. So I agree with Maggie that it is a framework agreement. And so it's not a contract of sale. It is, a membership. I quite like the analogy of, you're part of the club. So now you are a preferred, you've got the status of, we're quite happy to deal with you. And then after that, the details. But there are some overriding conditions and terms, one of which, the most important one here, is the jurisdiction clause. So they can modify things, but not the overall framework. So I think that's what the way I understand it. I mean, I can understand why you would have a problem with it, but therefore it's a contract within a contract. So maybe the wording needs to be sorted. So Maggie, earlier when you talked about, I can understand why, is this a contract or is this a pre-contractual, so I think that's where we get into trouble, because I agree with you, Tim, that you should not, the whole point of contract theory being based on consent is that indeed, and the judges and Coulson himself does say that actually you can, provided that it is, you can override things, because Coulson said, and I think that's where interesting part of the judgment is as well, amongst other things, that he says that looking at the way the parties were doing business, was it something that should have come as a surprise? I know it's not quite how he said it, but therefore here it's also a common sense approach. The parties always have the possibility, as long as it is clearly stated, that they disagree with it. And here that was not. So the overall, the signing of the customer file is indeed, Maggie, I can see, I'm not, we call it an umbrella agreement, a framework agreement. And within that framework, then we work out the details. What I find quite interesting is that one of the usual disagreement to all these things is the lack of certainty. So I think if we can bring that in. Usually the courts, we know that in relation to, as we tell our students, an offer has to be sufficiently certain. So here the court didn't even touch that. But could we argue that therefore the umbrella agreement was not sufficiently certain? That is another. But here the court therefore looked at it from a very business-like, look, that's how the parties did business before. There was nothing in TRW which showed that they didn't agree with it. So here we are. They've done that before, etc.
I think you have to remember the context of this particular claim, because it's not a claim at trial.
Yes,
it's a claim about the mini dispute as to jurisdiction.
You are right.
And that colours it greatly, because the hurdle for TRW to surmount over the first instance decision that's been made, I think is that bit much harder, as it were, because it's almost like you're sort of suggesting, Severine, that the court doesn't want to spend hours and days over these particular points. It's have we got enough to show that the jurisdiction is properly placed in England and Wales? So it's a kind of like a realistic or practical basis upon which to proceed, rather than a very close analysis perhaps of the ins and outs of the contractual terms.
No, you are absolutely right. Yes,
certainly we don't get into the merits of the dispute. It's simply whether the contract was made, for example, in England, or broken in England, or the terms are clear that it's governed by English law. And so that's really all one has to show. And I think that makes it so much harder for TRW once you've got a decision saying the weight of the argument is with the German side, that it's more likely than not that the terms here were German and jurisdiction was German.
Yes, that is very true.
Do you know whose argument always carries a lot of weight?
No.
Our sponsor, Newcastle Law School, because Newcastle Law School provides genuine research-led teaching so you can explore contemporary legal issues taught by experts in their field. Learn more about the International Commercial Law LLM or International and Global Challenges LLM by visiting ncl.ac.uk. Thank you, Newcastle Law School, for sponsoring us. Back to it.
That sounds very American, where a note from our sponsors and it comes in the middle of a program. That's very neat and US style. So I hope there's any US listeners, they'll appreciate that.
I do think we have a few US listeners, actually, so hello across the pond.
Dear cousins.
That's it. Right. I wanted to come in on two. So I like the common sense idea, but I'll come to that in a moment. I think the argument of certainty, I think, Severine, you were referring there to paragraph 33, where it specifically mentions certainty as one of the underlying ideas here. But I think that's undermined. I think that's undermined by having this idea that there could always be an agreement in the background that will override the new agreement, which means that no matter, particularly for companies, you would have to trawl through all that was there before to find these previous contracts that are there. What we want is certainty in that if I create a new agreement and I say, well, for this agreement, these terms will apply, then that should be it. Surely that's the way, if we've got consideration for that, that should be the overriding, deal. That should be it.
Remember,
so I don't think certainty is a good example here, or is a good justification.
The point I would make about certainty is that the parties decide what are the essential terms. And so the law doesn't interfere a great deal on that, as long as those terms are sufficient for there to be enough content for a contract. So the very basic things would be the items that you're buying and the price, for example. Beyond that, the parties decide what additional terms that they want. And there is certainty here because they are nailing down the specific terms that are important to them. So I don't think that's not going to get anywhere. If you look at the Panasonic terms, it does leave out the possibility of agreeing in the future other terms, buyer's terms. So on their own terms, it is not forever binding to this. Their own Panasonic terms have the possibility of a future contract of sale that is on a different basis than Panasonic's, but it nails it down. It has to be in writing and possibly, I can't remember, but signed by somebody from Panasonic. So they're not shackling a purchaser forever. There is some prospect of not dealing on these particular terms.
So, and that's where I can come in and say that's okay. So I think that does make it better if there's some kind of limit on it, if you can get out and move around with it. How I read it here was that there was almost no way out of this. And I would have
there is a way out, because you would have both parties, irrespective of that term, that says these terms will apply unless we agree other terms with you and we sign to that effect. But even without that clause, both parties could always in the future, unless there's some term that says otherwise, you can always in the future say, okay, we're now going to tear up those terms that we had agreed back in 2011 and we're starting on again on a different basis. That's always possible.
But didn't they do that? Isn't that exactly what they did when they say, well, let's actually deal on our terms and conditions?
Well, if you have a look at it in terms of, no, I don't think so. So I think that, and that was a point that Coulson made, that, the only possibility for the 2011 not to be binding is for the parties to make it clear in writing that they were disagreeing with it. So I think the problem with the battle of form is that, so by the fact that, again, so here we have to look at it in terms of the court, I think, and I'm going back to paragraph 33, and I slightly disagree with you, Tim, that it shows certainty. I think, again, if you read till the end of paragraph 33, I think they quote the fact that it is necessary in order to promote effective commercial relationships. So I think here the underlying, and I go back to the business common sense, etc., and looking at the interpretation of everything that the parties have done. And so dare I say here, they are looking wider than, the paper. They're also looking at the relation. So here we have the relational contract. Yes, I have made a plug to relational contract. That is very underhand. That is very, very underhand. But on a serious note, so here, I've lost the train of my thought. Do bear with me. So yes, the effective business relation is what is important. And so the problem with the battle of the form is that it is not necessarily always clearly indicated that this is what we're trying to do. So I think when Coulson said that a contract can always be torn up by effectively saying we are rejecting and we want you to agree in writing, he says that towards the end. I should have taken note of the paragraph. You are agreeing in writing that this has been torn off. So for me, that is not that is important in how the court.
But that's not a certainty point, is it? That is the Tim's point about future fettering. That the fettering of your future dealings, is it possible to tie your hands in that way? And the point that I think Severine and I were both making is that these particular terms were not a total fetter because of that provision that we could in the future. We don't throw out the possibility, we Panasonic, of dealing with customers on other terms than these, but you're going to have to go through a very careful process to evidence it in documents before that is so.
And that I can agree with, but I mean, then we have to ask ourselves, why not then have the position of being able to bind yourself forever and ever unamendably? Right, if we're going to allow that, right, and the superiority then of the contract document to the common law, as it were, then why couldn't we technically then bind ourselves forever? And I think here, I'm leading into something here. I think here the possible solution lies in, remember that case on good faith and lock in and lock out a few years ago? That was quite hot.
Petromec.
Walford and Miles, I think.
No, Petromec.
Yeah, Petromec, Walford and Miles and all of those. The idea was there that you can negotiate in good faith, or you can enter into a contract to negotiate in good faith, so long as you're locking yourself in, locking others out rather than you locking yourself in. And that seems to work by analogy here, I think, is that you could say, okay, you as long as you've got either a time limit or an exit strategy from the contract, as in possibly here, then it is okay to bind yourself, but not if it is forever.
I don't think English law has a stance on that yet.
I don't think so. I mean, you can.
It is possible to bind
I'm not sure about that, because
forever.
Staffordshire Waterworks, for example, they then imply a term that you can get out that after a reasonable amount of time the contract will come to an end. So that was the case of a contract for water supply to a hospital, I believe.
Yes.
But remember, for an implied term, that's going to be quite difficult and very fact specific,
it's an implied term
isn't
in law.
it? I'm just talking in principle. There isn't an English rule. Yeah, okay, but that's specific to that particular context. Nevertheless, in principle, English law doesn't, I think, have a view about whether you
I disagree.
are binding yourself
Well,
forever. It's within your power as a contracting party to decide for yourself. It's just unlikely, isn't it?
Well, I can't see how it would be accepted, and maybe the decision for the next podcast should be, actually, that's quite a neat point, Tim, about the Staffordshire decision, which I have to admit, to confess, I can't quite remember, but it seems to me that it seems impossible to say that an English court would agree that you can bind yourself forever, even.
Why not, though?
Well,
Why
I
not?
think,
Given the high position that we have for freedom of contract and freedom
Here comes
to
comparative
decide
law.
for oneself.
because then I think it would be. Well, I don't know. It's not possible in under French civil law, so that
Okay.
I'm
then
using
we might
a
need
way
to
out here. So
we
know.
might need to compare and contrast.
Yeah, no, we've got into comparative law. If you look at, so Tim mentioned the Petromake and the Walford and Miles. Here, one of the reason in the Petromake for looking again at Walford and Miles was that Walford and Miles, there was no terms, no exit strategy, etc., etc.
Sounds familiar.
So the court in. Yeah, no. In the Petromake, they said, as long as it is clear and certain. So in perpetuity, and agreeing in perpetuity might seem to be clear, but all the consequences seem unrealistic. Would anybody, would a reasonable man understand that? What would a reasonable man understand to be in perpetuity? So what does that mean in perpetuity? That if you die, then the contract goes in, to your descendants, etc., etc. I don't know.
Well, all of that would depend on the nature
Exactly,
of the contract, wouldn't it? I think it's just highly unlikely that anyone receiving legal advice would ever have gone down that
in
road.
any case, yeah.
So I'd be very surprised if there is a case that's bang on this point.
But
because it's an.
Well, it's quite literally South Staffordshire Waterworks is the case in which they bound themselves forever, and then we needed. Well, Lord Denning tried to do it. What was it, via frustration? But the others made it pretty clear that it was not. If I remember this, it's a long time.
Yeah, well,
since I
perhaps
read the
that's
case.
showing you what a rare event this is, and English law doesn't really have a clear response there. And I'm just suggesting to you that as a matter of principle, English law tends not to intrude in the decisions that a contracting party has made. If they've made them clearly and of their own free will, then in principle, you may bind yourself, as long as it's lawful, to anything. In principle.
In principle, but here I think in practice we are looking at a different beast. So, of something that I wanted to say earlier, if we look, so in light of the defining the signing of the customer file as a framework agreement or an umbrella agreement, as they referred to it, as Coulson referred to it. It's also important to see that the details, as you've said, Maggie, are to be sorted out in a different contract. And here it is important to note that actually TRW's conditions were much more elaborate, were much longer than Panasonic. So I think when we, effectively, so the supply were the beginning of the relation, and then the details to be sorted out in an individual contract, for want of a better word. So therefore, we're not really comparing like for like. So the process by which they decide how many resistors and on which price is then defined on an individual basis. So therefore, we have the overall relationship, if we want to try to differentiate, because I agree with Maggie, and I think, Tim, you made the same point of what is it that we are discussing here. So we have an umbrella agreement, and then within that umbrella, we've got sales contract. And so effectively here, the membership, to use your analogy again, Tim, that is what defines the relationship, but the details are to be sorted. So everything that came from TRW was a sales contract, and so therefore is a different beast for me.
Right, so I think
Well, I think you'd probably have to look at the wording of it,
Yes.
because it's probably broad enough to cover all of the dealings between these particular parties. So in a sense, it's probably, on their terms, broad enough to have covered the situation, were it not for the fact, as you say, that there was this umbrella arrangement. I don't know what Tim thinks about that.
what we're trying to say, or what I think the court was trying to say, is one of the difficulties was did Panasonic really know about what these terms were? And that's a point that you couldn't really argue. So it was just not given to them to argue this point. It's one of the difficulties I think we have with this objectivity approach is that did Panasonic have any clue, really, or at least their legal department, did they have any clue that they were potentially entering into this other arrangement that wasn't compatible, or wasn't really compatible with the overarching agreement?
It's not really a pertinent, acceptable question, though, is it?
No,
because
but that seems to be, to me, what they're trying to answer. It's a much better explanation for this weird judgment.
No,
Why? On which point?
Well, because it seems to me that what TRW were trying to TRW were trying to do is sneak this agreement in under the radar, as it were, knowing full well that there was this overarching agreement.
No, they were trying to say, if you look at the period of time between this umbrella arrangement and the actual purchases, I think they're trying to say that we got all this paperwork from Panasonic, but it did not to appear to a reasonable person that there was a connection between this paperwork and the eventual contracts that we entered into for the purchase of resistors. It was like 4 or 5 years apart.
Yeah, but they will have known that they had to go through the struggle of becoming
Well, yeah, I know you make quite a lot of that, and I suppose the Court of Appeal had to get over this problem about this umbrella arrangement and the status of it. But that's a point that I have real difficulty with, drawing an analogy between this and tendering, because tendering, you have the opportunity of making a profit and doing lots of work for someone in a contract. So you can see much more clearly there an obvious practical benefit in terms of a chance to make money. But to my mind, I hear what you say about, being a member of the club and all the rest of it. I still think that is commercially unrealistic. Panasonic will want to sell resistors to whoever they can get their hands on, and everyone that they can get their hands on. And it's rather abstract or unrealistic to say that somehow the customer has to pass all these tests to be in with the chance of buying from them.
I don't think so. I think that seems...
I've got to pass tests before I can buy something from someone. I would tell the seller where to
It
go.
is true that
you have not recently been trying to buy a mobile phone or any technology equipment, I think. But no, I think it's common practice. I mean, one of the particularly on the supplier side. This is quite unusual that this is kind of the seller side, but usually on the supplier side, it is very common that you want to make sure that you're checking out the people before you buy or sell to them. So Panasonic, for example, are probably used to dealing in extreme volumes, right? They're not just selling 1 or 2 resistors. This is going to be millions.
Yes.
One thing you want to make sure is, for example, the other company has the capacity to process it, has the money to pay for it, has the facilities to actually, you don't want to be dealing with numpty down the road. You want to make sure that you're dealing with other large businesses, for example, that can actually cope with what you're going to be doing. Panasonic has no interest in supplying their resistors to the little repair shop down the road.
I don't think that's realistic at all. I think a seller in the business of manufacturing an item, that once they part possession with this item, is gone to them and they don't care about it anymore. They really care about?
Except, as you said at the beginning, these resistors can also be used in weapons, and I think there is a point there is an element in the judgment to say that they're not making weapons of destruction. So I have to admit, when I read it, I thought, well, that's a bit left field, but now that makes complete sense. So perhaps it's also a way of vetting, and so that's why they want to keep that would make, if that is indeed the primary objective for this signing of the customer file, then that would make complete sense, that indeed they want to keep German jurisdiction, and so.
Yes, but do you see what I'm saying? That it's I think in conceptual terms, a different thing from passing a filtering test, as it were, a security test, armaments use test that is imposed by regulations, by international conventions or your own domestic statutory requirements. That, to my mind, is quite a different thing from a tendering arrangement and having the opportunity of buying from them in the future. The screening, the filtering thing is done because of external rules placed upon a manufacturer, a seller of items that could be used contrary to law, and they've used that in a sense to slip their terms and conditions into that scheme, and that's why I have
conceptually. Why shouldn't I be allowed to say, listen, Maggie, I sell you, I don't know, straw for the donkeys on a regular basis.
I can't use that in a unlawful fashion, though, can I?
You could create a big bonfire or something like that, which is, I don't know. But why wouldn't I be able to say from now on? I know you're one of my difficult customers. From now on, every contract we're going to have from here on out, I want these terms and conditions in. So you just have to call me and say, I want 20 bales. And I say, yeah, okay. That part I have no problem with.
I don't have any trouble with that. It's the analysis and the way in which it is explained that I have trouble with. I think it's fine to say, I'm not making an offer. I am the supplier or seller of something. I'm not making an offer. But if we in the future do business together, it is an understanding that any terms that we're discussing will be these terms. I think that's fine.
So would that just be the statement?
And you don't,
rather than a contract in itself? You're saying there's no contract for that?
It's no. Yes, I'm saying this is artificial to give it the language and analysis of a contract. It doesn't need to be that, and it's been made more complex by that. It is simply
that
the terms,
that I probably would agree with.
Trading.
How about this then? In the straw example, I say to you, you can be my preferred buyer. I'll give you 10% off if from now on out my terms and conditions will apply to all contracts that we use.
Okay, that's probably a bit different. If you say a preferred buyer, if I'm saying to you, okay, straw is short in supply this year, there's been a very bad harvest. If I am guaranteed to be always head of the queue, in other words, I will get delivery when other people might be left out at the end of the queue and not getting delivery, then I can see that actually would work analytically as a contract. Go. Yeah, I know, but that's not, you're changing the facts now. Okay, it's very fact specific. And all I'm saying to you is in this case, I don't think it really works. I think it's fine to say any future dealings between us will be on these terms and on no other. That's fine, but you don't need the language of this being a contract. It is simply that any offer that might be made in the future has naturally this embedded in it.
I think the reason why they have put it in terms of contract. It's because if we use anything else, then we get into trouble. So, Tim, you talked about a statement of intention. Well, we know that that is. Oh, I think you look puzzled by that, Tim. Maybe that's not.
I don't remember saying
what you
it,
said,
but something that I could have said. Yeah.
So let's say, yeah. So because if we say that the customer file is the statement of intention, then we go into the thing of whether that was, all the, letters of intent, intent, I think you used, but so a statement of intention or a letter of intent, then we need to have the problem of, okay, so did they mean to do that? And so that we know that the courts are not keen on, for certainty to accept that a letter of intention or a statement of intention or a gentleman's agreement has any binding value. Or can I finish?
No, it's not binding in the sense you talk about contract.
So,
yes,
and the other thing is, so you both use the thing of, if we do that, so could we, again, the other possibility would be a condition precedent, and then again we get into trouble. So I think I agree with you that it complicates things by looking at it in terms of a contract, but that is the only way it can solve the problem of the battle of form, because it overrides everything, and it makes it clear that this is the overarching thing. So anything else would have been more difficult to be convinced that it was binding.
I wonder whether that's the issue, that we've been talking about battle of the forms when really this is battle of the contracts. The battle of the forms, as I understand it from Butler Machine Tool, is that really the traditional analysis would be there's no terms and conditions. Right? Okay, I think Chitty suggests there's two. It's an offer and acceptance.
Well, it's an offer and acceptance.
Which here we don't have. There's no question as to whether offer acceptance consideration has happened on the first contract. No. And
but hang on.
We go.
Hang on. You can't talk about an offer and acceptance in the abstract. I go on about this to students. It's meaningless. It is simply a label. An offer of what? An acceptance of what? It's naturally, you've got to look at the terms. So an offer has some contents, and that is the terms. So you can't divorce the two from one another.
Yes, I would agree.
No, but it is true.
I don't think that's the issue.
Yeah, I completely agree with. I think here they are using, so whether you use a battle of form or the exception battle of contract. I mean, a battle of form is a battle of contract. It's you by agreeing to that, you're agreeing to the contract. So it is in terms of offer and acceptance, but effectively this is whether you have agreed to to my terms, hereby forming the contract, provided that there is consideration. And so but here for me that was the only way, for the reason that I've stated earlier about if you give it another label, then we get into more trouble to see whether this is binding.
Well, more accurately, we should be talking about battle of terms, shouldn't we? And that's why I'm talking about an offer is just a label. You have to think about what you're really talking about. You're really talking about the terms. So whose terms is this contract? And there is only one contract of sale. Whose terms is it that govern that contract, basically?
So are you essentially then? Are we essentially then saying, so when TRW says we'll buy resistors off you, then that's an offer that they're making the offer, but when Panasonic received it?
Panasonic seemed to...
They got an email,
Panasonic's terms seem to suggest that it is the purchaser who makes the offer. Mm-hmm. But what they're trying to say on this umbrella arrangement, as you call it, Severine, is that offer is implicitly made on Panasonic's terms. And therefore, the acceptance comes from Panasonic and naturally also on Panasonic's terms. That's the way Panasonic has drafted their paperwork, I think. And therefore, you don't actually need to talk about an umbrella contract or a pre-contract or any of that sort of construct. you only have to say that the paperwork from Panasonic, it was implicit in the dealings that they had that any future offer to be made by the purchaser would be on these terms that you, the would-be purchaser, have signed.
That's where and that's
that
where
I think would perhaps have been a clearer and a clearer bit of reasoning to this particular case, and it's become more complex than it needs to. And I think I can see why. That the point that we made a while ago now, TRW had an uphill struggle to find grounds to overturn the decision that had previously made.
Yes.
So they were pulling whatever they could out. So they were then trying to say, but there's no consideration. You've talked about this being a contract, this umbrella arrangement being a contract, but where is the consideration for that? So then the Court of Appeal was led down this road. They had to deal with that. They had to answer it. And so they said, there is consideration because it's like tendering or procurement. And that's, you've got one mistake, in my view, if I say that with respect, which has now become compounded because you've had to deal with that unnecessary mistake and complication with further complication, which I think is mistaken.
Yeah, I think in order to solve our problem, I think the judge at paragraph 46, so Coulson recognizes that actually the customer file, he talks about the ubiquity of the customer file and, responding to the fact that the signature doesn't amount to an acceptance. So I think, there is, and here Coulson, does say that, agreeing with the judge that the signature was not simply an acknowledgement of the document, it was so much more. And then after that, he does again at the end of the paragraph, saying it's a mechanism expressly envisaged. So therefore, indeed, here, it doesn't matter what we call it. The customer file is specifically designed. It is a mechanism. So maybe here we have a different word. And, again, I go back to the common sense and to the, efficiency or the need to look at it in terms of what makes sense in the light of what has transpired between the parties. And Coulson here looks again at paragraph 46, looking at the history of the commercial relations between the party. So therefore here, the customer file is a mechanism, is something which is done precisely to try to avoid any problems in the future.
I think I might use the label, it's ground rules. It was the ground rules for any future contract.
Yeah, I would agree with that.
That doesn't make it itself a contract. That's basically my main point. But it is the ground rules upon which we do later contracts.
Yes. And so therefore, I do agree with you that the whole thing is perhaps more complicated than it, the labeling it as a contract probably overcomplicates.
Sounds like we're
things.
Agreeing. So that's 2-1, therefore
Maggie
that's
and
it.
I, Maggie, we are, I know.
2-1 and we've won.
I do think we have reached the end. Although I'm going to persist. I have no problem in finding that this is a contract. The problem I have is being able to bind yourself beyond a second contract. That's
well, we'll have
that
to
would be my
agree
summary of my point, and I'm sticking with it to the grave. I've bound myself now for the rest of my time.
Okay, I think that is probably a good time to stop, but maybe we can, off the air, decide what should be our next podcast. But that is for us to do off the air. So thank you very much, Maggie and Tim, for the lively discussion. Can I also thank Luke for his editing and listening to us and telling me that I need to do a few things to help with the sound. So thank you very much. And with that,
thank
goodbye.
you very much, dear listener.
Thank you very much. And remember, you can always contact us on unpacking.contract.law@gmail.com. Thank you.